Hello everyone, hope you all are liking my videos based on concepts of law. I believe this could be of help for all lawyers, law students, and even students of ISC and CBSE board as legal has been introduced as an optional subject for class 11th and 12th. Today we are going to discuss the different types of writs in the Constitution of India. These writs are habeas corpus, mandamus, prohibition, certiorari, curanto. Anything that is issued under an authority is a writ. Orders, warrants, directions, etc. issued under authority are examples of writs. There are five major types of writs, that is, habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Each of them has different meaning and different implications. In India, both Supreme Court and High Court have been empowered with writ jurisdiction. Further, Parliament by law can extend power to issue writs to any other courts, including local courts, for local limits of jurisdiction for such courts. First, habeas corpus. Habeas corpus literally means to have the body of. This writ, the court can cause any person who has been detained or imprisoned to be physically brought before the court. The court then examines the reasons of his detention, and if there is no legal justification of his detention, he can be set free. Such a writ can be issued in the following example cases: when the person is detained and not produced before the magistrate within 24 hours, when the person is arrested without any violation of a law, when a person is arrested under a law which is unconstitutional, when detention is done to harm the person or is malified. This habeas corpus writ is called bulwark of individual liberty against arbitrary detention. A general rule of filing the petition is that a person whose right has been infringed must file a petition. But habeas corpus is an exception, and anybody on behalf of the detainee can file a petition. Habeas corpus writ is applicable to preventive detention also. This writ can be issued against both public authorities as well as individuals. Second is mandamus. Mandamus means we command. This writ is a command issued by a court to public official, public body, corporation, inferior court, tribunal, or government asking them to perform their duties, which they have refused to perform. Due to this, mandamus is called a wakening call, and it awakens the sleeping authorities to perform their duty. Mandamus thus demands an activity and sets the authority in action. Mandamus cannot be issued against the following: a private individual or private body, if the duty in question is discretionary and mandatory; against president or governor of state; against a working chief justice; to enforce some kind of private contract. A petition for writ of mandamus can be filed by any person who seeks a legal duty to be performed by a person or a body. Such a filing person must have real or special interest in the subject matter and must have legal right to do so. Prohibition. The writ of prohibition means that the Supreme Court and High Court may prohibit the lower courts, such as special tribunals, magistrates, commissions, and other judicial officers who are doing something which exceeds to their jurisdiction or acting contrary to the rule of natural justice. For example, if a judicial officer has personal interest in a case, it may hamper the decision and the course of natural justice. Difference between mandamus and prohibition. While mandamus directs activity, prohibition directs inactivity. While mandamus can be issued against any public official, public body, corporation, inferior court, tribunal, or government, prohibition can be issued only against judicial and quasi judicial authorities and not against administrative authorities, legislative bodies. Fourth, certiorari. Certiorari means to certify. It is a writ that orders to move a suit from an inferior court to superior court. It is issued by a higher court to a lower court or tribunal, either to transfer a case pending with that to itself or quash it or its order. This is generally done because superior court believes that either the inferior court has no jurisdiction or committed an error of law. The certiorari is kind of curative writ. Fifth, curanto. Curanto means by what warrant. This writ is issued to inquire into legality of the claim of a person of public office. It restrains the person or authority to act in an office which he or she is not entitled to, and thus stops usurpation of public office by anyone. This writ is applicable to the public offices only and not to private offices. In the end, I would like to summarize the different types of writs. Types of writ: habeas corpus, meaning you may have the body. Purpose of issue: to release a person who has been detained unlawfully, whether in prison or in private custody. Mandamus: we command. Purpose of issue: to secure the performance of public duties by lower court, tribunal, or public authority. Certiorari, meaning to be certified. Purpose of issue: to quash the order already passed by an inferior court, tribunal, or quasi judicial authority. Prohibition. Purpose of issue: to prohibit an inferior court from continuing the proceedings in a particular case where it has no jurisdiction to try. Curanto, meaning what is your authority. Purpose of issue: to restrain a person from holding a public office which he is not entitled. That's all for now. Do subscribe my channel for more interesting videos. Take care. Goodbye.